response as well to Justice Kagan's point is the thought that the limitations that exist in the habeas context are relative to the actual aim of habeas and goal of habeas, which is vacatur of the sentence. It's also not discretionary. Where the defendant has satisfied the criteria of demonstrating that his sentence is unlawful, the court has to, according to the statute, give him habeas. And so, yes, there are strict limitations, but there's also this particular goal. It seems to me that compassionate release is a totally different thing. And so, to the extent that compassionate release is about the court's consideration of a sentence reduction, one might think that the same limitations aren't intended to apply, that it's not actually an end run in any meaningful sense. These are just two different regimes, and it doesn't seem to necessarily follow that the considerations in one are mutually exclusive such that they can't arise in the other.
That's absolutely correct, Justice Jackson, and it's worth remembering that Section 3582 is as much an act of Congress as Section 2255 and should be given respect.
Is there anything in the statute or the legislative history to suggest that Congress wanted the 3582 sentence reduction dynamic to be limited in some way by what could have been raised in habeas or what is happening in the habeas scheme? Is there anything that links those two in the text or even in the legislative history?
Absolutely not, Your Honor. And in fact, the court has given guidance about how when there is a potential tension between two statutes, how that tension should be resolved, and that's the Prizer line of cases. And it's not simply that one statute can be seen in some circumstances to evade the other. What happened in Prizer in that line of cases was that 1983 was seen as a potential end run around every single constitutional 2255 motion. And that's why the court found that a literal reading of 1983 would swamp the habeas statute. It would wholly frustrate Congress's goals. Here, allowing defendants to bring motions under 3582 C1A in the rare circumstances that they could get relief, having a sentence reduction under those circumstances would certainly not frustrate the procedural limitations under habeas. And for reasons I said earlier, courts should actually take into account those procedural limitations.
And in fact, it would enable the kind of quote-unquote safety valve that Congress expressly in its reports, et cetera, in describing compassionate release. That's, I think, the design of it.
That's absolutely correct, Your Honor, and that's precisely how the two statutes sit one next to the other and not in conflict. Habeas applies generally to claims of error relating to a conviction or sentence. 3582 is the safety valve that can be applied to reduce a sentence should all of the other avenues of relief fail.